Horvath. Dennis has been practicing law in Ohio since 2001 in domestic relations matters. He handles cases in all areas of family law, including divorce, dissolution, custody, child and spousal support, and prenuptial agreements. Dennis has been selected as an Ohio Super Lawyer Rising Star several years and has been selected by National Trial Lawyers Top 40 Under 40 in Ohio, which is by invitation only, and is extended exclusively to individuals who exemplify superior qualifications excuse me, and leadership as a trial lawyer. In addition, Dennis has 10 out of 10 superb ABVO rating, and it's listed in Columbus CEO Magazine 2015 Top Lawyers, listed in RU Ratings, Best Attorneys in America 2015 ABVO, Client's Choice Awards winner, selected as Ohio Super Lawyer for 2016 and 17, in Columbus Rotary Club. This is a busy guy, he is awesome. Personally, I would like to say he has an awesome wife, 2 adorable children, and he's a great guy all around. Please welcome Dennis Horvath.
So my background, as Marla indicated, I am primarily domestic relations work. Our firm is about 85% domestic relations work. My partner, Barry Wolenetz, he does some civil litigation, estate work, and that kind of stuff as well. But primarily, we're domestic relations. How I got into domestic relations, I was actually working for a corporate firm doing just business transaction work, literally behind a desk every day. And I got real shortly into it, I got bored. So one of my friends said, "Hey, we're looking for an attorney. Would you be interested in moving over?" I said, "Well, what kind of law do you do?" She said, "Domestic relations." I had no idea what domestic relations was. I said, "Sure. Are you in court?" She's like, "I'm in court every day." I said, "Well, I'll do it." So that's how I started, and I kind of learned as I was going. Paralegals, I have found, my paralegals and my legal assistants, I have found are my most important asset. You guys literally make me who I am. You make my life easier. You make my job easier. Without you guys, I cannot be who I am. So you guys are certainly appreciated. So let's talk about generally what is domestic relations court. I know we have one who is in this practice area and one who has had some experience in it. But what is domestic relations court? Domestic relations court is basically dealing with family disputes. So we're dealing with divorce, dissolution, custody matters, support matters, anything that deals with the family and duties of husbands and wife, children. That's where we're going to be. That's where we're going to file. We're going to file in the Court of Common Pleas Domestic Relations Division. There's actually 2 that are within the domestic court. There's a domestic relations division, there's the juvenile division. Domestic relation deals with husbands and wives and deals with division of assets, debts, support, child-related issues. Juvenile court, that's where we're dealing with unmarried parents. So that's where we're dealing with custody. Again, we're dealing with support and those kind of things. So if we're dealing with married couple filing for divorce or dissolution or even legal separation, that you're gonna find yourself in the domestic relations court. If you're dealing with unmarried couple dealing with custody issues or support issues, then we're going to be in juvenile court. We'll kind of get into the 2 in the different kinds of cases that we will be looking at as we go through there. There's generally also 2 types of cases that will get filed whether in juvenile or domestic relations court. You're going to be dealing with a pre-decree, you're going to be dealing with a post-decree. Pre-decree cases, those are your cases. You file for divorce, and anything that deals within that divorce case, that's going to be pre-decree. So anything prior to a final judgment, that's going to be your pre-decree case. Post-decree deals with anything that's filed after we have an actual final judgment. So you have a divorce or you have a dissolution, you have a final entry or final judgment on that, and you have to come back for one reason or another. I guess an example of that would be if you have a finalized divorce decree, you have a shared parenting plan. In that shared parenting plan, the parties agree to exercise a certain period of time. Let's say husband has parenting time every other weekend, one day during the week, alternate, holidays. He gets a job he gets a new job, and his new job allows him to have a lot more time, a lot more flexibility. He can work from home. Well, he wants to now have extra time. He wants to have equal time. Maybe he wants to do a week on, week off. Talks to his wife. Wife says, no, I'm not going to agree to that. Well, guess what? We're going to have to file a motion. That motion would be called reallocation of parental rights or responsibilities, and you're going to be in domestic court. That's going to be a post-decree case. Same thing in juvenile case. If you reach an agreement, you reach a shared parenting plan, parties can't agree to how to modify that after there's been a judgment, then you're going to be filing a motion for reallocation of parental rights and responsibilities. Another ones that we file a lot of post-decree motions are contempts. A motion for contempt deals with when a party has not fulfilled his or her obligation pursuant to a divorce decree or dissolution or shared parenting plan. So if a spouse is not doing what he or she is obligated to do pursuant to a court order, that's a motion for contempt. That would also be a post-decree motion. Okay, let's talk about now briefly, before we get too far into this, what the difference is between a divorce, dissolution, legal separation. Those are really what we're going to be dealing with when we're dealing in domestic relations court. And I'm going to start primarily with domestic relations, see how much time we have, and then we'll get into juvenile court and some of those things. But I really want to get kind of into the nuts and bolts of divorce, dissolution, and legal separation. A lot of people don't know what the difference is between a divorce, dissolution, or as people when they come into my office say, I want a disillusionment. It's a dissolution. The difference is with a dissolution, the parties basically have to agree on all issues. So usually there's compromise between the parties. The parties will work together, usually come to an agreement on all issues, allocation of debt, support, custody issues. Once you have that agreement, then a separation agreement is prepared. That separation agreement is a legal document that actually contains everything that the parties agree to. If the parties are agreeing on shared parenting, there'll be what's called a shared parenting plan. That shared parenting plan will have everything in it that the parties agree to. You will then file a petition for dissolution. That petition is basically what is requesting the court to grant you a dissolution. You file a copy of that separation agreement, shared parenting plan. You attach it to the petition. You file that with the court. The court will then set a hearing within, usually after it's filed, it has to be within 30 days, but not longer than 90 days. So as soon as you can get it for a dissolution is 30 days. You can't do it any longer than 90 days or you'll be required to dismiss it. The theory behind that is things get stale, things get old, so that they want to make sure that everything is where it should be. So that's more of a compromise. That's more of a, that's more the parties getting along. That process is a lot faster. That process is a lot cheaper. But most importantly, the parties can control the outcome. You're not putting it in the hands of a judge or a magistrate who don't know you, don't know your facts. They have hundreds, thousands of cases that they're dealing with. And basically you get in court and they get a snapshot of your life and they have to make a decision. The reality is they don't know you, they don't love your kids. So they're going to be making decisions, based on what they hear at that particular time. So anytime I tell my client, if you can control the outcome of your case, control the outcome of your case. You don't want to put this in the hands of a judge or magistrate that do not know you. If the parties can't come to an agreement, which a lot of times they can't, we're filing for divorce. And that basically puts you in the court process. And how that's initiated with a complaint for divorce. And then, with the complaint for divorce, you're basically, at the court's mercy. You're going to get hearing dates set. You're going to have motions and pleadings that you're going to need to file, that you're going to have responses to. There's going to be court dates that you're going to have to, parties, you're going to have to miss work. You're going to have to schedule around that. You're going to have to make alternative arrangements for, childcare. These are things that people don't necessarily think about, when they're filing for divorce, but it's a reality. That process is much longer. So think about it. Dissolution, usually you will be done in 90 days, and usually you get a hearing right within that 30-day period, 30 to 45 days. Divorce case, the Supreme Court guidelines for a divorce case to be finalized, a divorce without kids is 12 months. A divorce with kids is 18 months. So think about that process. Think about being, stuck in a divorce proceeding for that long, and dealing with the emotional toll, every single day dealing with that. And keep in mind, Franklin County, which is where my primary practice area is, they're the busiest county in Ohio, yet they have the fewest amount of, as far as the divorce cases, yeah. and they still have the least amount of judges and magistrates. So they're significantly backed up. So when we say 12 to 18 months, I have a divorce that's pending right now that they don't have kids, supposed to be finalized in 12 months. We're going on 2.5 years. The problem with that is all these cases, you get set, let's say I get set for a trial date, and let's say I'm a divorce with kids, and let's say we're right at that 18-month mark. You go to court, and they'll set probably 3 to 5 other cases, contested divorce cases, on that same day you're set. And the way it goes is oldest goes first. So whoever has that oldest case number, whoever filed, earliest in that case or has the oldest case is gonna go first. So the theory behind that is they think probably some will get settled. Maybe some will get dismissed, maybe something will happen, and they'll come down to maybe 1 or 2, and that oldest goes first. So it's not uncommon to go down to court and get ready, get ramped up for trial, only to hear that you're going to get continued out for another 3 months because that's the soonest that we can get back in there, just because how busy it is. It isn't the judges or magistrates' fault, it's just how busy we are. They're working on trying to get some additional judges and magistrates. They added a few magistrates, but they want to actually get 2 more judges, so they're in the work trying to do that, and that would be really helpful. But just think about that process and how long that process is, moving forward. And if at all possible, you can come to an agreement. I always tell my clients, please do what you can to resolve your case. Yeah.
That 12 to 18 months is the court timeline based on if everything goes by their dates, right? So that doesn't include time built in for if the participants change their mind 20,000 times.
You know what, and that happens all the time. But no, they just, what the Supreme Court did is, now keep in mind, with the Supreme Court, they don't necessarily, all understand, a domestic relations case and how the domestic relations process works and how long it can actually take. The reality is if you're going to do the case right, and especially, what we've been arguing for attorneys is we need to have different tracks for different kind of cases. In civil court, they have like a complex litigation, scheduling. They don't have that in domestic relations court. We can have, it's not uncommon for our office to get a case where we have a client who has maybe 5, 10 businesses. So we have to name all those businesses as parties to the case. We have to get service on all these parties. Then we have to do discovery on all these parties. Just think about how long that process takes. Well, I'm sorry?
That's complex.
It's complex litigation, and we're dealing with tax issues. We're dealing with business issues. We're figuring out what portion of that is marital. So I don't think when they figured out this timeline, that's necessarily what they thought of. Now, mainstream America, where, we have, easy facts, husband and wife married, married 20 years, husband makes $60,000, wife makes $45,000, have a house, 2 cars, 2 kids. I mean, those types of cases, yeah, we can figure those out. We can go through the process. We can, the only difference with those, if we get into some complex child-related issues where we have some, issues with some sort of, if there's abuse involved or there's special needs children and stuff like that, they can get complicated. But to answer your question, no, that there wasn't really any thought process onto that, because some other issues that we come up with is service. Sometimes these parties will dodge service, or sometimes, like let's say in a juvenile case. We have maybe we have somebody who hasn't seen maybe we have a father who hasn't seen their child in 5 years, but wants to now, for whatever reason, maybe he had issues in the past, his life is back on track, now wants to establish a relationship with, he comes in, files an action. We got to get service on mom, and if he doesn't know where mom is, that may take some time. So there's always things that can kind of prolong the actual litigation process. But at the same time, that's what they came up with, so that's what we're bound by. And once you start getting to that, the courts, the judges and magistrates actually have to report, and they have to do a reporting of all their cases, the time frames, and if they're delinquent, meaning over the 12 or 18 months, they actually have to kind of explain why. Now, obviously, everybody in Franklin County, they all understand what the problem that we're dealing with, but as you get to some of the, maybe the Supreme Court judges who are looking at these stats, they may not understand why a case in Franklin County is so long and maybe a case in Licking County isn't taking as long. Well, the difference is the amount of cases that are being filed. Legal separation, with the legal separation, you don't see too much of that. But with a legal separation, what that is, the parties are still married, they're still legally married, but it honestly operates in the same process of a divorce. So you're dividing the assets, allocating the debt, figuring out child-related issues. So you have a final order that you're to follow, but you are actually still legally married at the end. You don't see a ton of that. Sometimes you'll see that for religious reasons. They used to do it a lot, elderly couples for insurance purposes, so if they want to say, because once you file for divorce or dissolution as finalized, you will automatically be terminated from your spouse's insurance. So there's no way around that. The insurance companies, they're going to stop, and you're going to have to get your own insurance. So elderly couples, you know, it's harder to get that insurance, or if you have some sort of pre-existing condition, you filed for a legal separation. So with that, you can still maintain your spouse's insurance, but the insurance companies have kind of caught onto that, so there's a lot of provisions now they won't even allow that to happen. And in fact, anymore, I tell my clients, check first if we're doing a legal separation, because most insurance companies now don't allow that to fly. They're going to terminate you from your spouse's insurance. So I always tell them to make sure, get something in writing, because the last thing you want to do is get stuck with trying to find insurance and not being able to do that. So that's basically the difference between those three things. So let's put all this into practice. So what does all this mean? So that's that's basically an overview of the domestic relations court, juvenile court. So let's talk about what generally happens when that new client calls. So the new client calls, new client comes in, what I do, the first thing I do, we'll sit down, we'll go over the case with the client, he'll kind of talk to me. When the client comes into my office, our office has just a basic, real short form. If we can get into them beforehand, we try to email it to them so we can have that information in front of us before we initially meet with them. If not, we hand it to them when they come in. It's just a two-page form. That two-page form just real basic information about them, and it kind of gives us an idea of what they're about. So they come in, I'll sit down with them. We'll go over their matter and kind of talk about, what their case is, what the issues are, and where we're going to go from there. Always important to have an engagement agreement. They're not required, but it's always in the best it's best practice to have an engagement agreement. That engagement agreement will basically outline the obligations of the client, but also of the attorney. If you actually go to tab 1 in the book, I have a copy of our engagement agreement. Guys, you would be surprised the amount of attorneys who don't have engagement agreements for whatever reasons. And I think a lot of times they just forget, or they think that they got it. The paralegals in our office, they always make sure we have it, because I'll be honest, I forget. I send it to them, and the client calls, hey, got to get on this right away. And so we jump on it, and I don't think to myself, while I'm hurrying up trying to get stuff done, did he sign that engagement agreement? Before we jump on the case, my paralegal or my legal assistant, they will make sure that there's a signed fee agreement, so we know. So if you look at actually tab 1, you'll see that that's our real basic fee agreement. We put in there in that first paragraph, obviously that's the name, but in the end there, we actually say the legal matter that we're working on. I didn't used to do that in my fee agreements, but I found that is good, because clients think when they retain you for a specific matter, you're their attorney for everything. Something happens, they get bit by a dog, the next thing you're going to hear is, why didn't you do something about that? I emailed you and told you I got bit by a dog. Well, it'll specifically say they're divorced. And then I can say, I represent you on divorce, that's why. So I put that in there. I didn't used to, but I do now, and I think that's a good idea. You'll see as we go down, it kind of outlines what our hourly rates are. Also outlines what paralegal or other legal assistance in the office is. I put in there what our retainer is. I don't start working on the case until I get the retainer paid and this fee agreement signed. Because it's really easy to start working on a case and not have that money paid, and then the next thing you know, the client says, I don't need your help anymore. Oh, yeah, we got that done, and then they disappear, and then you don't get paid. So, I mean, it doesn't make sense for us to do this for a living if we're not going to get paid. And the only way we're going to get paid, and the only way you guys are going to get paid is if the attorneys get paid. So it's important that you get that, you make sure you get that. And our office is great at making sure that those get done. And you'll see as we go in here, we bill at a 0.02 minimum. It's important to put that in there because clients inevitably will call you up and say, why did I get billed for that phone call? Or why did you bill me for the emails we sent back and forth? Well, because it says so right here that we're allowed to do that. And our office is really good about that. If somebody calls up and has a quick 2-second, I'm not billing them for that. I'm just not going to bill that. But if we're talking substantive legal issues, then yes. I mean, it's in there. 0.2. And you'll see in there that we, in the case that we have to go to trial, we can require an additional trial deposit. We have stuff in there that talks about what their obligations are. Payments of, for instance, if we need a forensic accountant, for instance, or we have a business, we need to value a business, we're not going to front that fee. It's an important, if we need to value husband's business, we need to hire a forensic accountant and business valuator to do that. That money needs to be paid by them. If they can't afford to do that, then we need to have another discussion about what we do to maybe settle the case. Or maybe we have a discussion if the spouse has money to, additional monies, that maybe we ask that they contribute towards that. But we specifically put in there that those fees, that they need to pay directly to the other one. That's the other thing that I make sure that we do. We make sure that our client enters into their own fee agreement with the expert and pays the expert directly. I don't want there to be any sort of confusion or any relationship issues between me and that expert, because me and that expert work together, on multiple cases. And I don't want him looking at me saying, hey, Dennis, your client didn't pay. What's going on here? That's their relationship. That's between the two of them. And if they have questions about that, we specifically put it in there. We talk about what the client's duties are, what we expect from them, what we expect, what they can expect from us. We put in here that we are making no promises, we are making no guarantees of what any results will be. We have right in there that we have a right to withdraw if client misrepresents, fails to disclose information. We just recently in a case, Mark, he was representing a client who we learned that he was not truthful with Mark. So Mark comes to me as a new lawyer, says, hey, I got this issue. My client told me that he was not truthful to me. Well, we withdrew. Because we're not going to get put in a situation where the court's going to question us. So if we know a client is not being truthful, if we know a client has made some sort of misrepresentation, we're either going to fix that misrepresentation or we're going to withdraw from the case. In this case, we withdrew from the case because of the nature of what the misrepresentation was. Always make sure this is signed by dated and signed by the client, and the attorney should also sign that. Generally the way that works for me is if I meet with the client in my office, we talk about it. He says, yes, Dennis, I'd like to retain. I'll get a copy. I'll go to my legal assistant or my paralegal, say, hey, I need a copy of the fee agreement, need a such and such amount. They'll put it together. I'll take it in there. I'll let them read that, and they'll usually read it and sign it. And honestly, they don't read it. They usually just sign it, say I'm ready to go. I always tell them, please read it or take it home and read it. I know you're hurrying through this because you want to go, but I want you to be familiar with this because inevitably they will have questions. Even your best clients will have questions. So emphasize enough, then put in writing. I always send an email saying, hey, just be sure that you review. If you have any questions to your fee agreement, please let me know. That way it's there, it's in writing. So usually I like to walk out with a copy of the fee agreement. I make a copy of the fee agreement from them. They'll usually pay the retainer at that time. These days it's not uncommon though for a client to call, for me to never meet that client, and the client will basically retain over the phone. So what I do in those circumstances, I will email them a copy of the fee agreement. I'll say, please review this. If you have any questions, please contact me. Otherwise, sign, return to me, then I'll sign and I'll email them a fully executed copy. That way we have it in a file. I'll email them back so they have a fully executed copy. But I always make sure that they have time. I don't want there to be any questions, any misunderstandings. So I always encourage them to talk to anybody that they need to talk to, whoever they rely on for guidance. Please talk, please, because I want them to feel comfortable in moving forward. So once that, I have that signed, the next thing I do for the client is I will email what we call our client intake, our client interview form. If you look at tab 2, tab 2 is actually a copy of our client information form. This is an extremely valuable form. For us, if you don't have one, it's really important that you should consider having one of these, and I think it's probably, I think this is universal for any case. It's particularly important for a domestic relations case because we're dealing with everything in the parties' marriage, the entire marital estate. So what we do is we have this in a fillable PDF form. So we can just email this to the client and they can fill it out online. So it makes it really easy. And then when they're completed with this, they just return it back to us. And then we have it. And you'll notice this has all information that our office will need in preparing all of our initial documents and pleadings. All the addresses, phone numbers, birthdays. If you go on to page 2, children. And you'll notice how this is set up once we get into affidavits that we file with our complaints for divorce that are required by the Supreme Court. You'll notice that there's a reason why we set this up the way we do. Moving on, it goes to the health insurance. The court wants to know who carries the insurance for the children and what that cost is. Moving on, we go to education, employment. Go on to income, all income-related information. Moving on, and if you notice on the bottom, they're actually numbered. I'm on page 12 of 30 of this particular document. But section 3, budget. Point out to the client how important it is to fill out a budget. This is one of the most important documents that you are going to need in a divorce case. The court wants to know what the budget is. I tell my clients to always provide substantiating documents because the court after all these years have called on that wife who's looking for spousal support or additional child support may not be completely truthful with her budget and may inflate that a little bit because if she wants this much money, she's going to figure out a budget to make sure that she gets that much money. Husbands as well who don't want to pay support, they're also going to inflate their budget. I have no money to pay support. What do you mean? Look at my budget. Look at everything I'm paying. I'm paying $5,000 a month in entertainment. How the heck am I supposed to afford to pay support? Well, the court's going to look at that and say, okay, well, we're going to get rid of that. And not only that, but it ruins your credibility with the court. So you're better to err on the side of just being, cautious. But if you can actually provide the documentation to substantiate the numbers you have on there, you don't need to do anything else. I mean, the court's going to look at that and say, well, there it is. There's no guessing involved. So that's extremely important. That's one of the most important things that you can have in here. And I provide them this extremely detailed budget with everything that we can possibly think of to have in there. Because as they're going through the budget, honestly, you'd be surprised how many people don't even keep a budget or don't have a budget, so they don't even know what their expenses are. So they go through this, they're like, oh gosh, I didn't even think of that. Yeah, I do this for gifts, or I spend this on a subscription. Just things they don't think about, and this kind of makes them realize, what their budgets really are. As you go into page 16, mostly your credit card payments and stuff like that. And you'll notice that we've continued to add lines to that because the more and more as we do this, people have more and more credit cards these days. So we keep adding those lines. As you move on to 17, we're dealing with real estate. Anything we're doing with real estate, the purchase price, and we have the mortgage balance, and if they know equity, any down payments and stuff like that, just to get an idea of the real estate that's involved. Going through, if you just skip to page 22, we start getting into retirement accounts. A lot of times spouses don't know what the other spouse has. Especially if you're dealing with one of the spouses that controlled all the finances, or maybe we have a stay-at-home wife who just relied on husband to deal with the finances, to manage the retirement accounts, and that kind of stuff, and they just don't know or have any ideas. Well, as we'll get to later, we'll figure that out through the discovery process, but if they don't know, they don't know, so just, I tell them, if you don't know, just put, don't know, spouse handled the finances. But you'll see it's extremely thorough. And this helps the client also get an understanding of their case as well. Yeah.
I just have to ask because most of this is, I think, what we expect to see.
Yep.
But I'm flipping ahead and I see frequent flyer miles.
Yeah.
People who fight over that.
They absolutely fight. People fight over everything. They absolutely fight over that. Let me tell you, I talked about this earlier, just to give you an example of what clients fight about. One thing that, everything that is purchased during, Ohio's a 50-50 state. So it's purchased during the marriage, it's acquired during the marriage, it's marital, subject to equitable distribution. So retirement assets, everything that was accumulated during, let's say, a 10-year marriage, that's marital. So that's getting divided. Anything that's purchased, that living room set, the dining room table and chairs, all that purchased during the marriage is marital, subject to distribution. Now, most of the times the parties realize that that's not worth arguing about, so they'll come to some sort of an agreement. Because what the court's going to do, that $5,000 couch that you purchase, when they're placing a value on it, they're going to give you garage sale value. So whatever you can buy that couch for at a garage sale, you're going to get. So you're going to get $300 for that, unless you have that valued. So you can hire an expert, you can have your client hire an expert, have everything in the house valued, but now we're spending more money than it's even going to be worth. So it's not worth doing that. You don't see, you get into that more when you're dealing with maybe art collections or antiques and stuff like that. But your normal, marriage, the clients will usually just come to an agreement. Frequent flyer miles, same thing. If they think they can get, a trip, or if they can do it, if it was acquired during the marriage, it is a marital asset subject to distribution. And people, like you said, they fight about everything. I was in a case where the parties resolved everything, but they could not resolve the household goods and furnishings. They literally wanted to, everybody, if he wanted it, she wanted it. If she wanted it, he wanted it. So we go to the court, we said, Your Honor, we're having some difficulty. We can't resolve the household goods and furnishings. Well, that irritated this, it was a magistrate. It irritated this particular magistrate. It was not in this county, so I will say that. It irritated this particular magistrate, and he said, well, I will not be wasting my time dealing with household goods and furnishings. I mean, the attorney, well, we don't really want to either, but, what are we going to do? So he literally pulled out a coin, says to the wife, heads or tails. I'm not kidding you. We flip its heads. He goes, here's what the two of you guys are going to do, points at the attorney. He says, you're going to go to their house right now. And wife, you get to pick first. We're going to do alternate pick until everything is done. And they had a big house. They had a huge big house, lots of assets that they were fighting about. Well, the magistrate thinking, attorney's thinking also as well, I'll take care of that. They're not going to want to do that. They're not going to want to pay for us to go there. Yes, they did. So for 2 days, I had to go to this house with the other attorney while they literally picked back and forth. Guys, not only did they pick them back and forth, but this is the stuff you see on TV. So wife says, I want the dining room. Well, you get the dining room table. Husband literally, well, I'm taking the chairs. It literally went like that. These people are going back and forth. They're arguing. Me and the attorney we're literally at wit's end figuring out what we do with these people. That was an experience. I won't let that happen again. Although I had it happen one other time. Last year, there was a client of mine and the spouse were at court. We're down to literally one issue. It's some mirror that the parties purchased when they're on vacation in North Carolina. Wife always had it. It's at wife's house. Husband decides, well, if this is going to get finalized, that's my last thing I'm going to do with her. I know how much that means to her, so I want it. Of course, it's marital. So we literally flipped the coin, and my client won it. So yes. Are you hating your friend who asked if you wanted to move over to the Well, let me tell you something. It's always interesting, and I've always got the best stories at any job function or any family gathering. I've always got the best stories, so at least provided for that. But
on one other point that you made, talking about marital assets, does that include how are inheritance treated?
Yeah, good question. If it is inherited, that is considered separate property. So anything that is inherited by a spouse, that is theirs. They can't touch it. So anything that's inherited or anything that is gifted, so if you gift something to your children, that's theirs. Nobody else, the spouse cannot touch that. And the only other thing is if it was purchased prior to the marriage. So if it's purchased prior to the marriage, you bring it in. So that dining room table instead, if you brought that into the marriage, you get to take that out. Retirement assets, if you started contributing in 1985, you get married in 2000, you divorced in 2017, everything from 85 to 2005, that's all going to be separate property. It's only from the date of the marriage to present that is going to be subject to marital. All this other stuff is separate. Any other questions? Mark, I expect more questions from you. Yeah.
Then someone inherits, but then they sort of commingle those coins?
Yeah, great question. Great question. So, what? No. As good as any. So let's say that you inherit, $10,000, just for sake of easy numbers. If you inherit $10,000, and then what I always tell my clients is keep that in a separate account. That way it keeps its separate property identity. If you take that money and you put it into an marital account, if you can trace that money, even though it's in that marital account, you can still get that. You can still be able to get that separate property. It's hard though, because if you put that in the marital, I mean, let's say you did that 10 years ago, that's going to be almost impossible to trace, because if you're using that account, it's going to be gone. So no, that's gone. You don't get to use that. You made the choice to put that in the marital account. You made the choice to use that for your family's benefit. So that's going to be gone. So and that's what's commingling. So if it's commingled, if you can actually trace it, and if you can make it, trace and link that separate property characteristic, throughout, if you put in $10,000 and that balance never goes down past that $10,000, you could probably trace that. But if it gets down lower than that, let's say it goes down to 3, it goes back up to 10, goes back up to 20, goes back, that's going to be hard to trace.
You would think they'd argue the intent was for it to be marital, putting both people.
You know what? When people get married, they don't think of this stuff. They think this is forever. You're never going to have to deal with this issue. So, you get an inheritance, you put it in, and generally you do for the benefit of the family. A lot of times I'll get clients who come in and whose family will say, hey, they've maybe been through the situation. Maybe they've had families that have been through a divorce situation. So they would say to their spouse, take this money, put it in a separate account, don't use it, that's yours. That creates a lot of animosity between the two spouses, because then the other spouse is like, what do you think? I'm going to try to steal that money? But the parents are just trying to look out for them because maybe they've seen it before, maybe they've had it happen. But it's like anything else. It's like a prenuptial agreement. Nobody thinks that you're going to divorce. You think marriage is forever, so you want to do what normal married couples do, and you're not thinking ahead, planning for a divorce and moving forward. Now maybe if it's in their second marriage, they do, because they've been through it and they're a little more cautious. So you do see that. But yeah, good question. Any other questions? Always ask if there's a prenuptial agreement. You'd be surprised how many people forget or selectively forget if there's a prenuptial agreement and it is not to their benefit. They a lot of times will neglect to identify that, despite the fact that it will always come out from the spouse. But it's good to have that. You want to read it. You want to see what that entails. Our office actually does quite a bit of prenuptial agreements. A lot of times we're dealing with that when we have a family business. The family wants to protect that business, so when they get married, they'll put language in this prenuptial agreement to reflect what will happen in that business, or that is to remain his separate property, or something to that extent. As you're going on, you get to the debts, and you kind of go through. We give them an opportunity at the end to kind of say, is there anything else you'd like to consider when dealing with that? That's the last page. usually get some pretty good stuff in there, where they're able to kind of vent and say what all the problems and whatnot. I will say when filling out these forms, paralegals make sure that they're completed. I always want them to review it, make sure that it's completed, make sure that everything is there because it's going to help make their jobs easier. It's going to help make my job easier. For whatever reason, it seems like the male clients are horrible at filling these out. They leave stuff blank. You're meeting with, I thought you said you had kids. I do. Why is it not in here? I forgot to put that in there. The females are usually great. They're very detailed, extra copies, other pages, talk about, the neighbor's kids, but they're really like mine, so that's why I put them on here. They're good. But no, make sure that those are filled out. Make sure that they're completed because, it's really important and really, like I said before, it really helps them get to know their case. I mean, you'd be surprised how many people say, gosh, I didn't even realize, that we had this, or I didn't realize that, this, or gosh, I don't know about the retirement. I should have been thinking about this, but I never thought about that. So, always a good idea to make sure that that's completed. Our office always makes sure that's completed. We generally we generally tell the clients, I can't start on your case till I get that signed fee agreement back, retainer paid, and that client information form completed. So that gets them on it. Usually they want to get it. So now that we've done that, moving on to what do we do next? How do we move forward? Client retains. I reel in the client. Client says, yes, Dennis, you're my guy. I wanna file for divorce, or I want to move forward on my matter. So this is where you guys come in, because 9 times out of 10, I'll get that call maybe 8:30 in the morning. I have court at 9:30, so I talked to him. I said, yes, we're going to jump right on this. So I'm going to go to my paralegal or my legal assistant, and I'm going to say, hey, remember Mark who came in the other day? He wants to retain. He wants to file for divorce ASAP. I'd love for you to get this done. By the end of the day, today or tomorrow, because of course you guys got nothing else to do, and I need you to jump on this. Well, you guys know nothing about Mark. You don't know anything about him. You don't know anything about his case. You don't even remember him coming in. I'm going to talk to you like you do, and that you should know, and that you should know everything about Mark. So here's where you guys come in. You guys are going to go. You guys, in all likelihood, what usually you're going to do is you're going to go straight. Okay, did he retain? If he didn't retain, you're going to say, hey, you're going to remind him, Mark, maybe shoot him an email, call him back. Hey, just a reminder, he needs you to send in that fee agreement. I think, I'm sure Dennis gave you a copy of that. If it's in, great. Make sure he signed up, filled out that client information form. If he didn't, remind him, say, hey, need you to do that, need you to look at that, need you to make sure that's done. So assuming that all that has been done, you have the form and everything, you're ready to move forward. So Mark wants to file for divorce. So first thing you're going to do is we need to figure out, okay, well, where do we file? So if we're going to file for divorce, we have to make sure first he's a resident of the state of Ohio. So if he needs to be a resident of the state of Ohio for at least 6 months in order for you to file in Ohio. Assuming that's the case, because I'm assuming he's calling me because he's a resident of Ohio, we need to figure out what venue. Venue refers to county, so we need to figure out what county we need filing. To file for divorce in Franklin County or any county in Ohio, you need to be a resident of the state of Ohio for at least 6 months, and of Franklin County or the county that they are residing for at least 90 days. So assuming he's been in Franklin County for at least 90 days, we can file here in Franklin County. So we will be doing a complaint for divorce. Next thing we need to figure out is, do we have grounds for divorce? Ohio's a no-fault state. So in Ohio, you don't really need to have a reason to file. There's a series of grounds. The grounds actually in Ohio are defined by Ohio Revised Code section 3105.01. Those grounds include having a husband or wife living at the time of the marriage. So if you're already married, you can't be married again. Willful absence of the adverse party for 1 year. Usually, if parties haven't been living together, Mark just had a case the other day, the parties hadn't been living together for like 20 years maybe or something like that. So I think that satisfies that requirement. Adultery, extreme cruelty, Now that's a good one. Extreme cruelty. Now, when we file complaints for divorce, and we'll go through a sample complaint, we always put in ours, in 99% of all divorce cases and counterclaims filed, extreme cruelty, gross neglect of duty, and incompatibility, those are the grounds that you're going to state. Because Ohio's a no-fault state, if for whatever reason the spouse denies that the parties are incompatible, then we have to prove grounds for a reason. In extreme cruelty, while that sounds awful, and people get served with a divorce and they see that, and they are fired up. They're like, look at what my spouse did. I mean, you know, extreme cruelty. This is absolutely ridiculous. I've never been extremely cruel to my spouse. Well, that's not really what all that means. I mean, it can be physical, mental abuse, but you know, continued mental abuse. Obviously, the court has a little bit of discretion in what they use for that. But you know, something like even a past domestic violence charge, that could certainly be extreme cruelty. So that's one ground. Another ground is fraudulent contract. Gross neglect of duty is another ground. That's the one I just said that we always put in there, and that's basically an omission of a legal duty. Husbands and wives have a duty to support each other. You know, they have duties of respect, fidelity. The Ohio courts have ruled that the court has broad discretion in defining what that is. It's more or less a case-by-case basis. No case is the same. You know, so there's no real hard, fast definition of what that is, but almost anybody can kind of prove that. So basically, that's what that is. Another ground is habitual drunkenness. Imprisonment of the adverse party at the time of filing. So if your party's in jail, I think that's probably pretty good grounds if you want to file for divorce. Procurement of divorce outside the state where the obligation of the marriage remain binding on the other party. So if you actually didn't get a legally binding divorce or dissolution from another state, you know, or if you weren't legally, I guess, also if it wasn't a legally somewhat binding contract, living separate and apart without interruption in excess of 1 year, and incompatibility. The last two are the no-fault provisions, living separate and apart in excess of 1 year, and incompatibility. Those are your two no grounds. So those are the two no faults that you can include in there. And like I said, 99% of all divorce cases will finalize, whether by agreement or through just the divorce. Usually it'll be stipulated that they're incompatible, or if they've been living separate and apart in excess of 1 year, because it just doesn't make sense to try to prove grounds. You know, most of these, you'll put adultery in the complaint, but usually the grounds will be negotiated, so that's not in there and that's not court record. I have had to use habitual drunkenness, which is always fun to put in the complaint as grounds, and that always upsets the other spouse. But let's actually go to tab 8. Tab 8 is a copy of a complaint for divorce that, you know, our office uses. You will note, obviously, the heading, Franklin County Court of Common Pleas, Division of Domestic Relations. You'll note plaintiff. With the complaint, you always got to have the name, address, date of birth, and social security numbers, and we only include the last 3 digits of the social security number, so that is not published. You'll notice paragraph number 1, that is our basic jurisdiction and venue provision, which states that in this case it would be Mark has been a resident of the state of Ohio for at least 6 months and of Franklin County 90 days. If Mark has children, we'll put that in here, names, date of birth of the children. Paragraph 3 basically states that, you know, they're owners of certain real personal property, so marital house, other assets which will be disclosed at the time of the hearing. Paragraph 4, talk about debt that the parties have. Paragraph 5 is where we talk about separate property. Always make that you know, it's always a good idea, even if you don't think there is separate property, allege it, in case there is. You never know what's going to turn up through the discovery process, and if you will find that maybe there was something that was there, maybe you did, or even that stuff that you got from your parents that, you know, is in your house. Maybe there's an antique, or maybe there's something, you know, something that, you know, you don't think of at the time. Even if there's not, we put that provision in there. Number 6 is our ground, so you'll see this is our typical, you know, guilty of gross neglect of duty, extreme cruelty, and the parties are incompatibility, the nature and extent, which will be more fully disclosed at the time of the hearing. And like I said, in all likelihood, this case will resolve based on the grounds of incompatibility. And then the last one is our wherefore clause. That's where we're asking, this is what we're asking the court for relief. So obviously we're asking, first sentence, you'll see we're asking for a divorce from defendant based on the grounds alleged herein. Designate him temporary and permanent sole custodial parent of the party's minor children, order to pay his or her separate debts, equitable distribution of the property, rightful share of the marital property, restraining order, which we'll get into as we go on here. And we always ask for, attorney fees and litigation expenses. So that's what our basic complaint looks for. That has everything that's needed in there to start. Now, if there was businesses involved, let's say Mark owns a flower shop or a candy shop, which would be fitting on Valentine's Day. We would need to add those businesses as a party. In this case, they would be party defendants. In this case, or we should say his spouse actually owns those. They would be party defendants in this particular case. We would need to find out who their statutory agent is, and we would serve their statutory agent a copy of this complaint for divorce. And we would also have other allegations in here that were specific to those actual businesses. So that's what a normal complaint would look for. Also, with a complaint for divorce, we also are required to fill out affidavits. These particular affidavits are required by the Supreme Court. They're uniform for the state of Ohio. So every county, any county in Ohio that you file in, these are the same affidavits. And if you go to tab 9, that's the first one. The first one is the affidavit of income and expenses. And you'll see that they're blank. These, you can just get these right off the Supreme Court website. And you'll know, if you take a look at this, you'll see income information on this one. Next page goes on to current, then you talk about kids. And then if you take a look at section 3, that budget looks pretty familiar, right? That's in our client information form. So it makes filling these affidavits out really easy because we can refer to that client information form that was filled out. And assuming that was filled out accurately and completely, my paralegal can prepare these affidavits without any further communication with the client. So we can get these done in short order just by filling out with the client the work that the client already did for us. So moving on, obviously we have monthly installments. Your credit cards, these are required to be signed by the party under oath, so these do need to be signed and notarized. If you move on to tab 10, affidavit of property, that deals with the real estate interests. Also moves on to vehicles, financial accounts, pensions, retirements, safety deposit boxes. And again, you'll note that all this is very similarly formatted to the client information form that we have, which makes filling this out easy. Again, these need to be signed by the client under oath, so they do need to be notarized. Moving on to tab 11, parenting proceeding affidavit. Each child, you're required to put date of birth, sex of the child, and where the child has lived for the last 5 years. You have to include all the addresses for the last 5 years. Again, all this is the same stuff we have and we request from our client information form from the beginning. Moving on to tab 12, that's the health insurance affidavit, requesting health insurance information. They're really only interested in the insurance. One, who's carrying the insurance for the children, and two, what does that cost? Reason is because in the child support worksheet that is prepared if child support is being paid, one of the calculations, or one of the figures that goes in there, is what is the cost to carry the child only. And that goes in, and that's a factor of the child support worksheet. So again, you'll note that these are all very, formatted the same as our client information form, which is why I place such an importance on that form, because it's important to be able to have all that information, have that accurately. And the reality is if you don't, what are you going to be doing? You're going to be calling the client up saying, hey, I need this. And then you're going to go into the next one. Oh, I know I just talked to you 10 minutes ago, but what's the make and model of your car? Okay, sorry, I need a budget now. I mean, it just makes it that much easier. Or you're going to meet with the client and fill these out, and that's going to take 3 hours. It's going to cost a lot more money in time for your client. So if they actually take the time on their own to fill that out, it's a good way for them to save money. It's a lot quicker for us to get the documents and the pleadings ready to be filed, and we can get everything done. So typically what we do is we'll take that client information form, we'll look at it, we'll complete all the pleadings and all the affidavits and everything, then we'll email it to the client. We'll say, review these. Let us know what changes you have. Let us know if you have any mistakes, what changes. They'll send it back, either say, great, looks good, or they'll say, hey, here's some changes. There's always some changes. So we'll fix those, we'll make the changes, and then we'll email it back to them. They'll give us the okay, and then we'll usually have them come in and then finally review and notarize. They don't have to. Typically, they like to because they want to talk about other aspects of their case. So they'll come in, they'll finalize everything by signing and notarizing it, and everything's good to go. They don't have to. Sometimes they'll, in Franklin County, everything's e-filing now. So a lot of times they'll just email it back to us. I always tell them to mail us in the original because we're supposed to maintain an original signature in the file, but they can email it back to us to save time, or if they're out of town, or if they're in another state, or even another country, and we can get those signed. Any questions as moving forward here? Okay. All right, after we have our complaint done, after we have our affidavits done, next thing we always make sure that we file our restraining orders. Before, what we did is filed a motion and affidavit. If you want to move to actually tab 14, that shows restraining orders that we would put on. Obviously, once you file for divorce, we want to make sure the assets are protected. We want to make sure that nobody's moving around anything, moving around monies, disposing of assets, hiding assets. So we want to make sure that that's not done. So the court will put on a temporary restraining order. Those are signed without a hearing. They're signed by the court ex parte, so no notice. They're just signed immediately. Now the court just recently, in the last few weeks, moved to, in Franklin County, what the courts do in a lot of the other counties, they are require now a standard mutual temporary restraining order. And if you turn to 13, what you will find is the court issued. This is standard now, this is required, this is prepared by the court. And what you'll see here is this specifically, once you file a complaint for divorce, this automatically goes on. And this is now binding on both parties. Before, what we would do is we'd file a motion for a restraining order. So if I'm plaintiff, I'm filing for divorce, I know I'm filing for divorce, I'm going to start planning. I'm going to start, hiding. Maybe I'm going to start moving assets. Maybe I'm going to stop contributing to my retirement plan because I know that, my wife is going to participate or is going to get half of that. Maybe I start direct depositing my check into a new bank account so it's not in the joint account. So all those things, we could do as we're filing for divorce. Now, once this is filed, this immediately goes on. If you take a look at this, you'll see paragraph 1, both parties are now restrained from directly or indirectly harassing. That includes telephone, text, email, social media, or doing any bodily harm. So, you can't, file for divorce, you get served with the divorce, can't have a spouse start texting, repeatedly and all these things. That would be a violation of this restraining order. You'll see number 2, you're not allowed to, sell, damage, destroy any of the assets that the parties have. You can imagine a lot of times you get served with the divorce immediately, the spouse may have, may be upset, so, they're going to say, well, guess what, I'm going to start selling assets, or I'm going to start destroying, all this stuff. Again, violation of restraining order. Can't change any beneficiaries on any loans, life insurance policies, or anything like that. So you can't cancel insurance for the spouse, can't do those sort of things. The main goal of this is to maintain the status quo during the divorce process. The court does want to make sure that the assets are not dissipated. Nobody is creating any debt that the other party might be responsible for as a result of this filing. It is important to note that if you are advising a client, you do want obviously to be mindful. You do now want to let them know that when you file for divorce, there is going to be a mutual restraining order on. They may want to stop contributing to that 401k. So if they're going to do that, they need to do that prior to the divorce, because if they're contributing to the 401k and the divorce takes 18 months, there's 18 months of contributions that the spouse may be entitled to. So that's a good idea. You might want to tell them to take half of whatever money is in a joint savings or checking account and to move that into an individual account. A lot of times you'll see this if you're advising maybe a stay-at-home mom who doesn't really have access to cash. You want to make sure she's protected, because it's going to take some time before you get some sort of temporary relief from the court, which we'll get into next. So you want to make sure that she has some cash in there to weather the storm in the event she needs to. So you want to be able to advise them that you might want to think about doing that. Now, is that going to head off the spouse that something's going on? Yeah, but at the same time, if you're going to be filing and shortly, it really doesn't matter too much. So you just want to make sure that all your ducks are in a row as far as finances, debts, assets before you file, because except for the checking account, everything's going to be restrained. You're not going to be able to move around, or stop, doing what you normally did. Reason checking accounts are not restrained is because the court knows people pay their marital, bills from that. So they want to make sure that you're able to continue to pay your bills. Yeah.
Does that stay in place, say it took 18 months, 2 years for the whole thing, or do you have to file to release something?
It does. That stays in place for the entire until the case is finalized. That will not be terminated until the final divorce decree or final, once a judgment is issued under divorce. That's going to stay in effect that entire time. Now, it's not too uncommon for parties to be able to file a motion for a temporary release of the restraining order. Reasons for that might be, let's say during the pendency of the case, parties decide, look, it doesn't make sense for us to keep this house, let's sell it. Well, you're under a restraining order, you can't sell that house. So if both parties agree to sell that house, we can file a motion for temporary release of the temporary restraining order, ask the court to allow us to release it for limited purpose of selling the house. So they'll allow that to happen. Or let's say parties are both strapped for money. Let's say this case has gone on for 18 months, still got to get ready for a trial. Both parties, don't have any money in a savings account, don't have any money in a checking account except to pay their bills, but we have a big let's say we have a big investment account, or maybe we have an annuity that's sitting there that could help pay, some of the marital bills, help pay some of the children's expenses. You can file a motion for partial release or restraining order for purposes of getting access to that account to divide it up. When you do that, usually it'll be divided up in equal forms, and that'll be considered, in a final distribution at the end of the case. So, except for those purposes, yeah, it's going to be in effect for that entire 18 months, so that they can protect the assets. After you file for divorce, you're also going, and actually even before, while you're in that process, you're going to want to talk with your client whether or not you want to request temporary orders. Temporary orders are orders that get in place until the divorce is final. Like I mentioned, you're looking at 12 to 18 months or longer before your case is finalized. The parties need to know what their obligations and responsibilities are for that period of time, because you can imagine if the parties are in the middle of a divorce, they are not in agreement with probably a lot. So they're not going to agree on who's paying what bills. They're not going to agree on what parenting schedule. They're not going to agree on what support is supposed to be paid. So if you actually turn to tab 15, this is also a Supreme Court uniform affidavit. This is how you request temporary orders. You fill this out and you basically state what you're asking for, And it's a real basic kind of check the box, fill in the blank type form. I'm sorry? Oh, tab 16, you're correct, thank you. So what this is you actually will fill this out. This will get filed with everything else, your complaint for divorce. And then what they'll do, they actually set this in for a hearing, is always set at 8:30 in the morning. Depends on which magistrate that you get. You'll go at 8:30 in the morning. And temporary orders are decided on affidavit. So the way the court deals with these is this is basically requesting it, but in Franklin County, you show up on that date, that's 8:30 date, and the court is going to see, okay, they're going to talk to you, they're going to say, what are the issues, what can you guys agree on, what can you guys not agree on? A lot of times we try to resolve them. Again, with the magistrate, I always tell them, look, you want to control the outcome of the case. The old, sometimes the devil you know is better than the devil you don't know. So you want to make sure that you can control what parenting time schedule you're going to get, what support you're paying, what bills you're going to pay. Because when you're doing your affidavits, this is a narrative form. So usually you'll show up, they'll say, okay, if you can't agree on anything, submit affidavits on all these issues in 14 days. So what that means is your client will submit an affidavit, and that affidavit will deal with custody, parenting time, support payments, allocation of debt, who's paying what bills, and whether or not you're going to pay some sort of attorney fees or expert fees, depending on the type of case it is. So those temporary orders, as you can imagine, your client is writing these affidavits. So it's important for you to tell the client to be as thorough as possible. You also need to understand that this is what the court is going to review to make its decision on these temporary orders. So it's also important to tell your client these are submitted simultaneously. So if they're submitted, they're usually going to be submitted on that 14th day by 5 o'clock. Everything's e-filing, so you submit it by 5 o'clock, you get a copy. So you don't get the benefit of seeing what the other party filed. So you always have to anticipate what the other client has filed, or what your spouse is going to file. So it's important for you to tell hey, look, if you haven't been completely honest with me about whatever issue, it's going to come out here. This is where they sling the mud. These affidavits are where they tell everything that they do. I'd love to say that clients are all truthful in these affidavits, but these are just nothing more than an opportunity for clients to exaggerate how horrible the other spouse is. If husband has a few beers a week, in that affidavit, you're going to hear that he drinks a case of beer a night and drives with the kids, all night long. So, these are the things that you get in these affidavits. So you want to be prepared. You want to make sure that you don't overdo it as well, because again, the court reads these every day. The court, kind of knows, what is, valid, what's not, can kind of see through, some of the issues. But guys, these are one of the most important documents you'll file in your case, because that's the status quo for the next 12 to 18 months. When the court issues these decisions, you're going to have maybe shared parenting. That's going to last until this case is finalized. Maybe you have a parenting schedule. Again, that's going to set the status quo. That's going to last for the case. Support, debt. So it's really important that you're thorough and that you include everything you want to include. I tell my clients to, give me the history of the marriage, and to, give me everything that you have, and let me be the filter. Let me go through it. Let me kind of go through and figure out what's important and what's not. And then it's kind of an ongoing process until we get it finalized. Did you have a question? Yeah.
What happens if you have a child who is underage, is a minor at the beginning of the process, but is going to be not a minor before even the process is midway through?
Yeah, good question.
How does that change then? Because won't that change the status of the temporary orders?
It will. It will. And the court loses jurisdiction after the child turns 18 or graduates from high school. So assuming that, let's say the child is 17, you submit temporary order affidavits, you get an order, parties have shared parenting, they have a particular parenting schedule, and then maybe 5 months later, graduates from high school, turns 18, child is now emancipated. What will happen is that we can file then what's called a motion pursuant to Civil Rule 75. And that's how we ask that those temporary orders be modified. So if we get an order, and this goes true even if we don't like the order, if we get a client and you're like, look at this, look what my spouse put in, there's nothing but full of lies. None of this is true. All this stuff is completely exaggerated. We'll file a motion pursuant to Civil Rule 75. The way that is dealt with in Franklin County is it's another set of affidavits, so it's basically a response of the other affidavit. In other counties, you actually have hearings. In other counties, you actually have little mini hearings on the temporary orders, which I like more because these affidavits just give the clients an opportunity to just totally go overboard with stuff. You're limited to 24 pages, and a lot of times you'll use every bit of those 24 pages. You have exhibit after exhibit after exhibit, and it's just hard to go through. So then you get an order that's, you feel is based on inaccurate information. Then you have to file that motion pursuant to Civil Rule 75. Then you're back in a couple months. Then what the court does is they allow you to submit additional affidavits, which basically is nothing more than a response of the other party saying what a big liar they are. And then you have the opportunity to have actually like 10 to 15 minute stand-up oral argument where you can just basically argue why you believe that the magistrate erred in her order. In your case, that'd be a pretty easy one because everybody recognized by statute, child is emancipated, court no longer has jurisdiction. So that would usually be done by agreement of the parties. They would agree to amend the temporary orders to, if there was a child support obligation, so that would terminate, and that parenting schedule would no longer apply, or if there's any expenses that they were paying for this child, maybe some sports fees or whatever, all that would end unless they agree otherwise. Did that answer your question? I'm sorry, that answered your question. Yeah, thanks. So temporary orders, real important. You got to make sure that your client does a good job with them. I've seen attorneys basically just let their clients write them because it's their affidavit, and then they submit it. That's a train wreck. Don't do that. You got to edit it because look, we know what the courts want. We know what the courts are going to review and look at. So make sure that you include everything that's important for the court to consider during that period of time. And like I said, if you don't like what the order is, we can file the Rule 75. But again, that's another set of affidavits that the court has to consider. So, but do discuss with your client whether or not they're needed, and if you can come to an agreement. I think it's really important again to know the case and to know whether they're needed. A lot of people won't take the time to talk with their clients and get to know their clients, and they just go through the process, file this, everything, templates, sign, and submit. And it may not be appropriate for the case. Maybe the parties have been living separate apart. Maybe they've already agreed to a parenting schedule. Maybe they just have some minor, issues that they can't resolve that you need to file for divorce. You need some help with a judge on. But you file all this, then, it kind of puts you in that litigation mode, and then nobody's really inclined to want to agree to things. So it's real important to get to know your client and to make sure that, you are filing stuff that's appropriate. Or maybe you, as a spouse, is, the high, income earner, and, you're going to be paying support, you're going to be paying spousal support temporarily, you're going to be paying attorney fees, and you don't want to give your wife any of that because maybe she's been having an affair and she has a boyfriend, so you don't want to pay for that relationship. You're not going to file for temporary orders because you don't want them to do that. Now, inevitably, wife will, but, at the same time, there's no reason for you to do that additional step if we're not asking for them. So once that's done, and once you request temporary orders or not, next thing I always make sure we do is discovery. The discovery process. For us, it's not required. It's not something that you need to do initially at the beginning of the case, and not everybody does. I always do because you just don't want to forget to do it, and I like to issue my initial interrogatories and requests for production of documents just with initial basic information, and then as the case goes on, I can do another set to kind of determine what makes sense and what doesn't. If you turn to tab 17, that's actually an example of the initial interrogatories that we send out in a case. And number one, just your basic information. Number two, whether they know of any non-expert witnesses, what they think they'll testify to, 2 and 3. 4 witnesses, 5 expert witnesses, 6 any exhibits. Now it's always going to be too early for clients to, for the other side or us if we get this to know at this particular stage. Sometimes sometimes you know what stuff you're going to ask for, but I always ask this as the case goes on, and then it's out there because the parties do have a duty to provide these responses, even if they don't know. They'll usually unknown at this time, we'll supplement. So I have it out there, so I don't want to forget to do that. So as you're getting close to trial, and let's say they have 28 days to respond to this discovery. So let's say I'm 14 days before trial, and I realize I don't even know who their witnesses are. And then I look through the file, I never requested discovery. I never asked for this stuff. They don't have to give me that stuff. Unless there's a scheduling order by the court or the court orders it, they don't have to necessarily tell me that, and it would be my fault. So I can say, hey, wait a minute, I know, we forgot about this, but 12 months ago I sent you this and I requested it, so you need to do that, and the court will require them to do that. So it's just better to send these out early on so you don't forget about it. And then as you get to know the case, as the case goes on, you can then tailor another set of interrogatories specifically to your case facts. Same is true with the request for production of documents. Tab 18 is an example of a request for production of documents. This stuff is always relevant, and it's always good to send this out in the beginning of the case. You'll note Exhibit A, which is page 3 of Exhibit, our tab 18, tax returns, earnings, deferred compensation, fringe benefits, employment documents, trusts. As you'll see, you go through that. It has all relevant financial information, and that goes back to the client information form when I said, a lot of times spouses don't know that information. Here I request it so I can fill in that blank if need be, and I request it. Again, not necessary to do it at the beginning of the case, but again, you don't want to forget, and this gives you the opportunity to get the basic stuff you need. And then look, when you get that information, that's probably going to lead to other stuff you need to follow up on. So maybe it leads to another bank account that you didn't realize that your spouse had. Maybe you didn't realize that he was entitled to bonuses from that employment contract and he'd been hiding them all these years, and you find those, those bonuses. So, it's good to do that, and that would allow you to, ask for additional discovery, maybe about that bank account that the bonuses have been in. Maybe, you can issue, maybe if there's something you find out about, the employer, that you issue a subpoena to that employer. So it's better to get that out early, and then again, you can always do as many as you want throughout the case as the facts come out in the case and as you don't, or as you get to know the case. One of the biggest mistakes I see is that that parties don't do this initially, and then you forget. You get involved in this case, you get involved in your other cases, and then they just forget to issue discovery as the case goes on. And then here you are, again, 14 days of trial, you have nothing. You have no discovery, you have no documents. The other big mistake that I see them do is they'll issue this stuff, they'll get it, and they don't do anything with it. They just let it sit in the file, and they don't review it. I always have my paralegal go through everything that I receive, tab it, make sure it corresponds with every single question. So 1, what was responded, tab 1, 2, tab 2, tab 3, as you can tell from my book, I like tabs. And I go through, and I make sure, and then I look to see what is missing. And then a paralegal will send an email out to opposing counsel, say, hey, you didn't provide me with, with your K-1s to your tax return. You didn't give me your 1099s to that, or I'm missing, these 2 months from your bank account, and then we'll send it out there, and you stay on top of that stuff. Because if you don't look at this stuff and you don't do that, you're going to get to trial, or you're going to get to the end of the case, and you're not going to have important stuff. Usually if they don't give you a 1099, but they give you everything else, there's a reason. They probably didn't tell you about that job. If you're missing months from a bank account and, and they have a stack that big, there's usually a reason if they've given you, everything else. They're hoping you don't find it. And I'll be honest with you, a lot of people don't go through this stuff and look at it. And, and you get to that case and the clients will look at you and say, what the heck, we didn't know about this. Or you find out about it at, a trial when it's too late to do anything about it. So that's one mistake that I see, other people do all the time is, even if they send out this, they just do it because they know they're supposed to, but they don't do anything with it. So make sure you go through that, make sure you tab that, make sure you have, you identify what is missing, so you send those follow-up emails, so you have everything you need, and you know that your case is ready when you need to have your case ready. When talking to clients as they come in, you want to make sure, as we're getting ready to file the case and we're going through this stuff, because you'll know if you look at actually my last on the last request, I asked for computer program and printouts, copy of computer files, programs, printouts, and the like. I've also now started asking for social media accounts, social media Facebook history, and those sort of things because, again, people don't plan for a divorce. So, you go through somebody's social media and you go through their Facebook accounts, you're going to find great information. And guys, people can't help themselves. I mean, even when you tell them, look, don't post anything on social media, I promise you, as I stand here, your client, their spouses, they're going to do it. And even when you tell them not to do it and they don't do it, their friends will do it. And their friends will then say stuff about how awful, the friend. I got a case now where I have a client who is not being, for whatever reason, he was not allowed to, the parties were never married, was not allowed to see his child. So, comes in, hey, we're going to file an action in juvenile court. We'll make sure that everything is, is moving forward. We're going to put everything in action so you can see your son. Meanwhile, just, keep doing, don't do anything. Don't, meanwhile, his family's posting all this stuff about how awful this person is, using their name. This person is not allowing to, our son to see his child. And, that, well, of course she sees that because she tags her in that. And then, that stuff comes up. And then obviously, that gets imputed to our client, like my client intended for the spouse to do that. So always want to make sure you advise them, make sure they check that, make sure, honestly, guys, it's best not to have those accounts because nothing good is going to happen from them, through this process. So always talk about, social media. It's a mistake if you don't address that with the clients that, they need to be mindful of that. The Instagram post, even, if, they're doing the subtle messages, that, are up there, but, they don't say anything, people know better. And I'm going to make a copy of that. I'm going to look, my client's going to send it to me, I'm going to make a copy of that, and I'm going to find out how, I can use it to best suit the client. So whatever you do, make sure you talk to them about the social media aspects of the case, because it's really becoming my best witness in a trial. I'm in the middle of a trial now, where the other litigant is a reallocation. We're trying to change the custody, trying to terminate shared parenting, and the mother continues to post stuff about what an awful, person her baby daddy is, without naming names, like that's like nobody knows, and how awful his attorney is that he would file such and enable this guy to. But she's posting this, of course, he's sending this stuff to me, and what is that? What does that show? That shows that she can't share parent with this guy because she's putting it all out there on social media. And not only is she doing that, but she can't even help herself in the middle of trial. I mean, we're in the middle of a trial, and I go for day 3, and I have these posts, and and she continues to do it. People can't help themselves. So just be mindful of that. So now that we have a complaint, we have all the affidavits filled out, we have our mutual restraining order that we're going to file, we request temporary orders or not, we have all that ready to go, everything's ready to be filed, client has approved it, client has signed off on it, everything's been appropriately notarized, we're now ready to file. Talk to your client about service. You will need to have your spouse Personally served, it's usually done in divorce cases by a private process server. You can do it by certified mail. Usually, if you're filing for divorce, there is that animosity between the parties, so they do want somebody showing up at the door and serving them. They do, for whatever reason, they do get some satisfaction from that. But do talk to your client about when to serve them. If you know the children are going to be around, talk to them about that. Don't serve them when they're with the children. If the parties aren't living together and he happens to have them, don't serve them when the children are there. I try not to serve them if they're at work. There's really no reason to make a big scene over getting them served. I don't want to do anything that's as much as my client would probably like to embarrass their spouse. There's no benefit from that, so I'm not going to show up at work with the process server and do that. Now I will do that if they're dodging service. If they know we're serving them and we're knocking on their door, or we try to serve them when they're leaving the house or something like that, or we know they're going to be at a particular place, we try to serve them, and they're dodging service, and we're left with no other choice, then yeah, we have to do that. We have to go, and get them served at work. Yeah.
Well, working at Nationwide, we work with the service process team, and we get that a lot of people are trying to serve the husband or wife, and those that we accept services on behalf of the company, and we have sticky. We can't accept the service on behalf of a husband or wife. We can call up there and see if they're available.
And it'll come down, right?
Right, and it's one of those things where people think that they maybe are creating a scene, but in our experience, it's like, I can't make somebody come, or they're moved out of Dublin as opposed to the downtown location, and it's really sticky.
Yeah, there's a lot of places where I personally know that, Chase is another one where it's difficult to serve people at work. Nationwide, it's difficult to serve people at work. I'm not even going to try. Because I know that you guys can't accept service on behalf of the spouse, you can't on behalf of the company. But if it gets to that point, then usually we know their work hours and we'll get them in a parking lot. Or something like that. But again, we don't want to do that if we don't have to. But you get those cases. You get those cases where they just don't want to cooperate, and they think that somehow by not getting served, the divorce is just going to go away, or the spouse is going to say, okay, you know what, you were right, I'm not going to do it now, I couldn't serve you, so let's make this work. They're going to get served. It's going to happen, so one way or another, so it really doesn't make sense. That's the same thing. A client will come in and say, yeah, I'm trying to get served, but I'm not serving. I'm like, why? You're just prolonging the inevitable. Take service, or if they retain me, I'll call up the attorney and I'll say, serving on me will waive service. No reason to get them served. So got to make sure that they're served, get them personally served. Talk to your client about how service, should happen. When it makes sense. You usually don't like to serve. If they're living together, you try to do it when the parties aren't together. You get a lot of that. Most of the time when the parties are living together, the spouses kind of know it's coming because they do have some sort of talking. But look, I got cases where husband lived in the basement, wife lived upstairs, wife decided she wanted to file, knocks on the door, husband gets served, had no idea it was coming. They show up and they're angry but typically, you try to serve when the parties aren't together. You want it to be the least confrontational, process that it can be.
I just wanted to share, because I work with Dennis. Dennis has done a lot of work for our family, that I wasn't aware that if you have your process server is having issues, and we had one case, a huge issue from getting served, they can certify someone in the family or group or whatever to serve. And so I wasn't aware of those alternatives. I just thought that was interesting.
Yeah, what we do, we have an individual who we use who has a company. He's our process server. And what will happen is when the documents are served, we identify him as our process server. Once the service packet that the court puts together is done, they'll leave it there for him. He'll pick it up. He'll call us for instructions on how and when to serve this person. If you can't get somebody served, it doesn't have to be a process server. As long as it's not a party to the case, I can serve somebody, I've had to serve somebody before, you can designate a family member as a process server. You just have to have an order appointing them as a process server. So yeah, it can be almost anybody as long as they're not a party to the case. So yeah, that's potentially something that you have to do. So once you figure all this stuff out, have everything ready to go, you're ready to file the documents. Like I said, Franklin County is all electronic filing. So make sure that everything is in order, and then you file. My paralegals file everything for us electronically. After your case is filed, you will be assigned a case number, judge, and magistrate. It's totally random who you get. And that will be your case number, judge, and magistrate until you're basically forever, until you are out of the system and until children emancipated. But if you ever come back, that will be your judge, that will be your magistrate. The only way that will not be your judge or magistrate is if the judge retires, is not reelected, then you'll get whoever replaces that judge. And same with the magistrate. If the magistrate decides to maybe go into private practice or leaves for whatever reason, you'll get the magistrate, whatever magistrate replaced them. So you will have that magistrate, and the reason is obvious. They're familiar with the case, they know the facts. 9 times out of 10, they'll remember the case, so they'll be able to best know the issues. And plus, you don't want people shopping for a judge, or maybe a judge is better on spousal support. You don't want them to try, dismiss and then refile with hopes that you get a better judge or magistrate combination. You're stuck with it. So when you do that, when you file, that's who you're going to get. Another thing to make sure that you guys do, and this is actually page 5. Any divorce or dissolution with kids in Franklin County and all other counties actually, but this is for Franklin County, you are required to take a parenting class. These parenting classes are available now online, so they're real convenient. You can really take them anytime. But again, people forget to tell their clients that. And although the parties will get a copy of this when they're served with the divorce pleadings, people forget, and you will not be able to finalize your divorce or dissolution if this class has not been completed. And there have been situations where I've been to court, we've been ready to do an agreed upon final divorce case, and the other party never took the divorce class. And we couldn't do it. We had to wait until he took the divorce class, and then we had to reschedule the uncontested divorce. So make sure you tell them, clients, to do that. Make sure they get a copy of this information. There's no reason not to do it now with being able to do it online. So you want to make sure that's taken care of.
Can I just ask a question? You just said uncontested.
Yeah.
What's the difference between uncontested divorce and dissolution?
Yeah, good question. With a uncontested divorce, that means that at some point during the process, the parties came to an agreement. So let's say you file, we have everything ready, we file for divorce, husband served, he retains counsel, we start talking about the facts of the case, we get in maybe 5 months later, parties realize that, hey, you know what, we're really not that far apart, let's, we want to control our final outcome, let's enter into, let's come to an agreement. Parties, counsel come to an agreement. We can do what's called an uncontested divorce. That means that the parties reach an agreement. That will be prepared in what's called an agreed judgment entry decree of divorce. If the judge issues a decision, that's just a judgment entry decree of divorce. Parties reach an agreement, agreed judgment entry decree of divorce. What that allows us to do then is basically we will prepare that agreed judgment entry decree of divorce. If there's kids involved, share parenting plan, and those documents will actually have a final agreement of everything that's in there. I think, let me see, I have a copy in here so you can see what that looks like. But what that means is uncontested can mean actually one of two things. Look at tab 21. There's 2 ways we can do an uncontested. The first one is parties come to an agreement. Parties come to an agreement, we prepare this document right here called Agreed Judgment Entry Decree of Divorce. As you can see, this document will go through and discuss all issues related to support, parental rights, responsibilities, if there's shared parent plan, the home, what we're going to do with the home, what we're going to do with the vehicles, bank accounts, debts and expenses. This document means the parties agreed on it. Parties came to an agreement, parties entered this agreement by themselves. What we will do is, and usually in Franklin County what we can do is we can go talk to the, whoever judge is assigned to this case, we can go talk to their court officer and say, hey, we have an agreed judgment entry that we want to finalize, we want to come on in, and we want to get this done as soon as possible. There's two reasons for that. One, the judges are more than happy to do that because that takes another case off their docket. But the other reason is because we don't want to lose the clients to this agreement. We don't want them to, change their mind, something to happen, something to blow up, something to go, where they decide, I don't want to do this agreement anymore. So what we do is we put down this agreement. The court will usually say, yeah, actually you can come next week on this day, or we can come next, you can come this week on this day. We'll show up with the clients and counsel, and the court will look at these documents, and the court will, in all likelihood, everything, if there's two counsel on board, everything will be as it should be, and the court will actually grant your divorce on that day. So although you filed for divorce, you guys were able to reach an agreement, and you guys were able to finalize that agreement by way of an agreed judgment entry to create a divorce. Again, you're controlling the outcome of the case. You're able to finalize this based on terms that, although maybe you don't like, you can live with in going forward. So that's basically what an uncontested is. There's another way to do an uncontested, though. The other way to do an uncontested divorce is if you serve the party, you file everything, get the party served, process server serves them, they now have 28 days to respond. So if they don't respond within 28 days, obviously they're in default. In Franklin County, the court allows you to file a notice of uncontested divorce if after 42 days the spouse does not respond or answer or defend in any way whatsoever. So if after 42 days there is no response to your complaint for divorce, you can file, and it's actually a notice, and then you have to actually serve the other party with a notice of the uncontested divorce. So that notice of uncontested divorce will get set at a particular day. You must have service of the other spouse on that day. If that spouse does not show up on that day, the court will go forward if you have good service on everything and they have notice of that hearing date. Now, what will be required of you is, obviously that will not be a agreed judgment entry, that will be a judgment entry to create a divorce. Basically, we'll put in what we're asking for our client as far as a final divorce. And you are required to bring a witness with you because there will be no spouse on the other side. Basically, this witness will testify as to the truthfulness of your client and that the testimony he was given was truthful and accurate. Now, what the court wants when you go there, whether it's an uncontested or it is by an agreement or whether it's because the other party doesn't show up, the court is required for us to verify that the party has been a resident of the state of Ohio for at least 6 months and in Franklin County for at least 90 days, so you have to establish jurisdiction. You will put in there if it is if the party did not participate in the proceedings, you're going to want to go and tell the court what efforts you made, that you got service and that you sent him notice and shown that you have notice. You're going to want to, if it's by agreement, then you're going to want to verify that you reviewed the agreement, you understand the agreement, you didn't sign the agreement under any sort of duress or coercion, and that you understand it. You also have to verify that you are not in bankruptcy proceedings, and you have to verify that you are not in any branch of the U.S. military, and if female, you have to ask if they are currently pregnant. Because if you are currently pregnant, then you cannot proceed because they have to establish paternity of that child. Now, albeit it is presumed if it is born during the marriage that it is the result of that marriage, the court does require that paternity be established. So you will need to establish paternity. I have actually had that happen again. I've been up there. Other side asks the easy question, are you currently pregnant? And she says yes, and everybody looks and says, okay, now what? So we had to wait for the baby to be born, and literally we had to wait 8 months for this baby to be born. Baby was born. Luckily, the agreement did not blow up. We had an agreement, everything finalized. It was not my client's child, and the case ended up finalizing. But those are the questions that you do need to ask. You do need to ask those questions, whether it's a divorce or a dissolution, because the court wants to make sure that you're entering into this agreement of your free and voluntary act. So that is basically the difference between or what an uncontested and contested is. So while we're on the topic, what is a contested? Contested means that we're going to go through the divorce process. We can't come to an agreement. We're heading towards trial. We have the temporary order process. Temporary order process is usually the first court hearing that you're going to have. That'll get set. Usually that's set somewhere 30 to 45 days, depending on whatever magistrate you get docket and when they schedule their temporary orders hearing, because they obviously want it after service. They want to make sure that there's enough time to get service and that the other party has time to get counsel and show up. You'll show up for that temporary orders hearing. You will then figure out what you're going to do on affidavits, come to an agreement, submit affidavits or not. You'll deal with that. The next hearing that you're going to have after that is going to be a pretrial. Pretrial is actually going to be the first time you go in front of the judge. And that is basically the judge's first introduction to the case. The judge is going to take a look at, he's going to want to hear. Judge doesn't make any substantive decisions during that time. Judge is just going to listen to, what the case, what the facts case, what the case is about. And if there's anything that the court can help you with, any particular decisions, then that's something that the court will help you with. If you look at tab 20, that is a copy. This is something that my paralegals put together for me. That is a standard pretrial statement that the court requires. And you can see basically just kind of describes the issues in the case. And then as you see on page 2 of that, you have, if you're plaintiff's position, if you're defendant's position, you kind of go into those things. I generally also attach a proposed balance sheet of what I know at that time. And I also will try, if it's appropriate, a proposed child support worksheet. Something I like to have my paralegal start on from day one on the case is starting to get together a working balance sheet. Again, it's amazing to me how many attorneys don't have balance sheets that they're working from. I mean, we're dividing a marital estate, we're dealing with assets, debts. How can you figure out what is a fair distribution if you're not actually dealing with a balance sheet? So my paralegal will, from day one, will get one started, even if it's blank. As stuff comes in, she'll start to fill that in. Maybe we have we know what the value of the house is. We'll put the value of the house in that balance sheet. Once we start maybe getting discovery in from the other spouse, as she is tabbing that discovery, I will also have her start working on that balance sheet. So as she's going through that discovery, she'll start inputting these values so we have kind of a working copy. And again, it kind of just helps you become familiar with the case. It helps you early on know the assets, debts, and the case, and it helps you stay on top of it, because you're also going to see in the balance sheet is what I use at trial, and the balance sheet is what I use, to kind of go through my exhibits. What I do when I have trial, my first insert is the marital balance sheet. And with that marital balance sheet, I will have a corresponding exhibit on each one. So usually real estate, that's my first column. I'll have real estate, and then we'll talk about value. If I have an appraisal done, there it is. There's that exhibit. If I have a mortgage balance statement, there's that. So I'll just go through the list like that, and then you can start, as it makes sense, assigning to each party what kind of makes sense for that particular asset. If the wife wants to keep the house, then she can keep the house, and she can, that'll go on her side, of the balance sheet. So always important to if you can, to jump on that, get the balance sheet going so that you can make sure you stay on top of that. It's the most important thing that I can say for that. What happens if your client comes in and he or she has actually been served with a complaint for divorce? At that stage, you're going to need to do what's called an answer, counterclaim. And again, it's the same process. I have my client, even if they've been served, I want them to fill out the client information form because it's going to be the same process. You're going to want to make sure you have all that information so that you can accurately fill out the answer and counterclaim. If you move to tab 19, in domestic relations court, you're going to do an answer and counterclaim generally when you do your complaint for divorce, when you do your answer. So as you'll see, generally, just like on my complaint, you're generally dealing with the first ones with, jurisdiction, child-related issues, so you're going to, admit or deny the specific allegations as appropriate. And then you'll notice on page 2, that's the counterclaim. That's almost identical to the complaint. It's just called a counterclaim. That's the defendant, doing a counterclaim, also requesting a divorce, and that's what he is requesting, for purposes of his case. I always do I do the exact same thing. In that case, I issue discovery. You do not need to do personal service at this point because there is generally an attorney on the case who filed that stuff, so you can serve them specifically on them. So really the process is basically the same process of a divorce. What happens if your client comes in, they file for divorce, he gets served, 28 days has elapsed, you have 20, and I assume you probably all know, you have 28 days to respond to that complaint for divorce. So the 28 days has elapsed, you're on, let's say, day 35, client comes in, says, oh my gosh, I haven't responded to this. Well, what you want to do is you want to file a motion to file out a rule. That is freely granted. Usually if there's an attorney on the other side, you can call them up and say, hey, so-and-so just retained me. I just got a copy of this. I know 28 days has passed. Will you agree to me filing this out of rule? Out of rule just means I'm filing it outside of the 28 days that's required for me to file my answer. They will always agree to it, and even if they don't agree to it, or for some reason you can't get a hold of the attorney and you want to file immediately, the court will freely grant that. It says right in the civil rules that the court will freely grant that. So you actually send up a motion with a proposed order, and the court will sign that, and it'll be filed as if filed on that day. So that takes care of that. Yeah.
Well, they usually wait beyond that 42 days.
They won't. The court won't do anything if you don't. So. Yeah, so unless you bring that to the court's attention, the court won't on its own do anything with that 42 days. They'll just let it, keep going.
Saying, so if you have someone who comes in late, so they come in on the 43rd, that's what it says. So yeah, about 42 days, if no one else has filed anything, they won't have done anything with it.
If, well, let's say, maybe this will answer it. Let's say that there's an uncontested already date set. Let's say my client gets notice that it's set for, he gets served, and then he gets served with a notice that an uncontested hearing is set for this particular day. Then he comes in and says to me, I just got this notice of uncontested. All I need to do is file my answer, and that goes away. So they won't do anything with that. It's only if nobody makes an appearance, or even if, client shows up at court on that day and says, hey, wait a minute, I want an attorney. They won't go forward. It's only if they don't show up and they got proper service of all that they will show up. So.
You get many people where their spouse is just going to represent themselves to pro se.
You get a lot of that. You get a lot of that. You get a lot of that, particularly in juvenile court, for whatever reason. But you do, and that's really difficult because the pro se litigant doesn't trust me. Because I'm representing their spouse, so it's really hard to get anything accomplished, and really the only way that you get anything accomplished is when the court starts doing stuff, because they don't understand the process. They think that they do. They've read about it online, so they know how to be a lawyer because it says so online, and. What they end up doing is making more of a mess, for themselves than, if they would have just spent money. And then they're spending more money trying to fix the issues that they created when they do ultimately hire an attorney. These pro se litigants are treated as though, they're an attorney.
Well, it seems like the forms are more available now.
They are.
And so you would think that there would be more people thinking,
There's
oh,
a
I could just do
self-help
it
desk at these
Yep.
domestic court.
There is. There is. There's a self-help desk. The forms you can find everywhere. You can buy them, online. And I'll be honest with you, people come in and say, gosh, I tried to do this dissolution, but they won't accept them because of any number of reasons. Well, these forms are so general. I've had clients come in saying, I don't understand why, the court won't accept our, dissolution documents, but they told me to go see a lawyer. You look at it and literally it says everywhere in there that this is governed by the state of Texas. So It's true. I mean, it's, you know, it's like, it says everywhere in there. You know, it's like, I'm like, well, here's problem number one is we're in, you know, Ohio. This is, well, isn't it all the same? Well, no, it's not all the same. You know, so yeah, it's so true though. Everything is available, and they are inundated in juvenile court with pro se litigants. They have help desks. You know, you can go to, if you're of low income, you can go to, you know, the legal clinics, and, you know, and they will help you. But that doesn't help them when they're actually in court. That doesn't help them file a temporary order affidavit. That is, you know, the most important thing. It doesn't help them properly file an answer, you know, so they can kind of get an idea of the process. But when you get in there, you know, it's frustrating for the court, you know, because, you know, it's hard to get anything, you know, finalized because they're not going to come to an agreement with me because, like I said, they don't trust me. You know, they don't think that what I'm telling them, you know, and I'm not going to tell them anything that's not going to be supported by law. I mean, I'm going to, you know, zealously advocate for my client, but the court knows that I'm not going to do anything, you know, that is not going to be something that a court would do or something that's not necessarily going to be, you know, fair under the circumstances. But it's hard, it's impossible to deal with, you know, pro se clients. And another issue, guys, that we deal with is we deal with the, you know, you got to understand this process is a horrible, horrible process. It's emotionally terrible on the clients. You know, they are literally in the worst time of their life. Their family is breaking up. You know, maybe they're under the realization, you know, that stay-at-home mom who's raised these children, you know, at home for the last 6-7 years is now realizing she's going to not have half the time with them. Or, you know, the dad who, you know, is, you know, coached all the teams and is, you know, is realizing that he's not necessarily going to have the children on that day. You know, they are in an emotional time. A lot of times, you know, you guys are the first line of defense. Because, you know, if I'm at court, these clients, they call more than probably any other practice area you have because they are so afraid of making a mistake. They're so afraid of, you know, losing their children or the court doing something that, you know, is not, or, you know, can I, you know, buy this? I know there's that mutual restraining order. Am I allowed to spend money on this? I mean, so they're calling constantly and they're in an emotional wreck. So they're not normally who they are. And the reality is that you guys, my paralegals are first line of defense because they're calling, they need to talk to somebody because they're in crisis and I'm at court. So who are they going to call? They're going to call the person who helped them fill out their initial pleadings because they have a relationship with them. They're going to call the people who send them an email, you know, following up. I need a copy of your pay stub. You know, they're going to reach back out to them, you know, because I'm not in court. Now, you guys can't answer legal questions, but guys, we're just as much counselors as we are attorneys in this practice area. They're calling us for, you know, advice, and a lot of times I'm giving life advice. I'm not giving legal advice because they're calling because they're, you know, don't know how to respond to a particular situation. You know, what do I do? You know, my husband's girlfriend is coming to pick up the children for his parenting time. What do I do? You know, I can't tell them to violate a court order. If there's no provision that says his girlfriend can't pick up these children, as horrible as that is, I can't tell them to. They don't understand that. They don't want to hear you have to let them, you know, go. They don't want to hear that for an answer. So this is, you know, a difficult, you know, area, and a lot of times, you know, we're their only friend. You know, you have families who are in complete turmoil because they're broke up. Maybe a family's, you know, maybe they don't have anybody who's local. Maybe their family's all in a different state. They moved here with their spouse, you know, and they feel like they're getting ganged up on by, you know, a spouse. They really need somebody to talk to. And my office is fantastic at that. Even when, you know, they don't want to talk to that client because, you know, that client says, I just got a quick question. Literally a 2-minute question. You know, they're going to have, every question is 10 minutes and they have 10 of them every single time, you know. But, you know, the reality is that the longer you put them off, the worse it's going to get. I always tell my clients, I always tell paralegals, you know, Mark, I always tell them, you know, if you're there, if you can take the phone call, take the phone call. You know, it's going to 9 times out of 10, it's going to resolve the issue. It's going to settle them down because, you know, if you don't take that call and you don't tell them what to do when a girlfriend shows up, the next thing you know, that's going to turn into a domestic violence action. Because this, you know, they're going to get in an altercation because emotionally, you know, they're in a horrible time. You know, they're not in their normal state of mind. They say, spouse says something to girlfriend, girlfriend's going to defend her man, so she's going to say something. The next thing you know, the police are called, and you're getting a call, by your client saying the police are here. Now what do I do? So, if you can just, calm them down and, take that call. Even my paralegal, even if she has to, take that call. The other thing is in our practice are these clients, they show up all the time. They just show up. They don't have an appointment. I'm not there. A lot of times they'll just show up and say, oh, hey, I'm just dropping off my discovery, but hey, is Dennis here? Can I just talk to Dennis real quick? If I'm in court, the next thing they're going to say is, well, hey, can you just tell this to Dennis? That's always an hour later, But at the same time, they feel like, they're getting that attention. Our paralegals in our office know that, and usually, honestly, they diffuse the situation. Usually, when they're done with my paralegal or my legal assistant, they don't even need to talk to me. Most of the time, it's not a legal issue. They just need to feel like, somebody's hearing them, somebody is understanding, the issues that, they're going through, and that we have a plan and that we are addressing those issues. I think my time's just about up. Any questions that I can answer? Any questions that yeah?
So, in uncontested divorce, how do parties actually agree on terms? Do they just agree by themselves, or do they go to you for advice?
It's almost always with the help of the attorneys, because a lot of times, they don't know what, clients don't know what the law is. Wife may say, I want to keep the house. I've lived there, we raised our kids there, I'm going to keep the house. A lot of times there's an emotional tie to that house. They want to keep the house. Wife has not necessarily worked during the course of the marriage, so she has no income stream. Now, maybe she gets support, but I need to explain to that client that, well, there's $200,000 worth of equity in that house. That's a marital asset. Your husband's entitled to half. So you're going to have to refinance that house. You're going to have to remove his name from the note and mortgage, and you're going to have to find a way to pay him $100,000 as his share in the equity. Okay, they may not realize that, and they're thinking, okay, well, wait a minute, how am I going to do that? Well, then we have a conversation. Well, okay, maybe this is more house than you need. Maybe you really don't need this. Your kids are grown, your kids are out. Why not sell the house? Why not get the money from the house and just go to something smaller? And you explain to them, I get it, it's an emotional tie, but think about this as a break. You're going to get away. You're going to feel so much better when you're away from all those memories. And so stuff like that. And then they'll realize, yeah, Dennis, I thought about it. I'm going to buy a condo with the proceeds of the house. I'm going to have a smaller payment. So we help them get through that issue. They don't necessarily, understand that they're going to be splitting up half their retirement account. So we have to explain to them, hey, this is what the law says. They're going to say, well, that's not fair. I don't want to do that. That's not fair. My spouse was having an affair, so I don't think, they should have anything that I accumulated during the marriage. Well, Ohio law doesn't care. It's a no-fault state, so they don't care the reason for the divorce. You don't get more of the marital estate because you had an affair. So, a lot of those things take, consulting with your client and explaining to your client what the law is. And once you tell them, hey, look, I can argue this till I'm blue in the face, but, this is what the court's going to do. Generally, they'll be able to understand that, and they'll be able to come to an agreement, realizing that this is, what they do in Ohio, and this is what, the court is going to do. So it's almost always. Now, child-related issues, a lot of times they will come to an agreement on the child-related issues, because I tell them, I don't know your schedules. I don't know what you do on a daily basis. I don't know, what activities your kids are involved in. I don't know what time your activities are. I don't know what your work schedule is. I don't know what your work schedule is. You guys need to tell us what works for you. And then we can then formulate that into a shared parenting plan, with the rest of the language that makes sense. So a lot of the time the child-related issues, the parties will resolve just because of that, just because they can work out their own schedules. They know when they can get to a particular place or not. So a lot of times it is with the help of the attorney. Any other questions? All right, well, I think that's my time. I appreciate you all for paying attention today, and hopefully your significant other is good to you. Otherwise, you can tell them about the seminar you're at, and you are ready to go. So thank you all. Appreciate it.